committee meeting yesterday. So I know he's been
He's on his radar again.
yeah.
Mr. Lane? Don Hubb?
Bright shirts on that side of the room today. What's that?
We didn't get the memo.
Apparently we forgot to wear drab.
Sorry, but you left yourself wide open on that.
A lot worse.
But that's me the rest of the week.
Hey, John.
Yeah.
I talked to Mr. Danton yesterday.
Okay.
He's like ready to pull the trigger as soon as he gets himself. So I didn't know if you were ready to email that or not, so.
So I don't have that exhibit. But you can walk over there and figure out where that's at.
Let's walk over there after this and
Okay.
get your card. We're not talking about it today. Who knew carpet be such a heavy topic? Let me tell you. Can you guys maybe go around and join us when you can? Well, welcome everybody. Today is May 5th, 2023. This is a Board of County Commissioners work session for the Land Use Code. John, are you ready to kick us off here for Chapter 13?
Chair, I'm happy to do whatever you like. Where do you want to start, or how do you want to approach this?
Is everybody, you guys ready?
Well,
Well,
I got one quick question before we get started on our, the one that we have on file here, Carl, is the highlighted stuff we removed, or what is,
The highlighted was where we had kind of an initial discussion about it, and a couple of things were flagged, for John to look at. And so those were where some changes were made, either by John or myself, based on, the conversation we had with the board at that time. So like, for example, subsection E, under unlawful subdivisions, and subsection C, non-liability, those were changes that were made, following the prior board discussion.
just another stupid question, if you printed a clean copy of this with everything Xed out, how many pages is it?
One,
Cause it's 8 with everything Xed out, so.
probably about half that, 4, let's say.
Okay.
And before we get started, Carl, did you or Don have an update on SB 23-213?
I looked at under the bill tracker, and it looked like the House had passed it on second reading with amendments. But I asked Robbie if she had any updated information on that, or.
I have.
That was the best I could find at this point.
I gotta call in to see, but they haven't got back to me yet, everything's a little crazy over there, but, I know there were some friendly amendments that they were fighting for. Most everything in 213, was mostly gonna be affecting, municipalities, not counties. But, you know, they could turn around and make it affect us next year, so.
Wait, so
Typically
nothing,
what they do, but right now I don't have a solid update, but mostly everything that's in there will not be, most of it will not have an effect on it.
then we're gonna move forward as if there won't be any change to what we're doing here.
So Carl, was someone gonna put the version up to see it?
No. We have it in front of us, John.
Well, let's make sure we're all looking at the same version. There's no right version, the same version. So the last version that I saw that came through was from yesterday's date.
I took it out of the larger document and made sure that we all had to send it out so that we all were all working off the same.
Is that what you all have?
Yes.
Okay, wonderful. Okay, again, Chair, do you want me to just start talking about this, or do you have particular
Well,
questions?
we have been through this once before. Section 1, under B remedies, number 4, we had flagged civil infraction.
Okay,
Is that in also in your notes? That we were further review.
so civil infraction is zoning violations under 30, 28, 124, are civil infractions. The statute says they're civil infractions. And this is a change up from last year. So there's a lot of, as you're aware, the legislature went through many violations and essentially lowered them. Many county ordinances, and this is a county resolution, but it ends up being the same kind of force of law. Many things are now civil infractions. So, it is a civil infraction. Some of this. I think that what is before the board today, in relation to that only, is whether or not to authorize the penalty assessment procedure.
And I think also, who has the authority to issue that citation? It's written that the code compliance officer may issue a summons complaint. Should be following a board hearing. There's been some comments about that the board should hear it before the code compliance officer issues a summons and complaint. We also have the code compliance advisory committee. So kind of, you know, at what point in the step does it need to come to the board before that, does it need to come to the board before that action is taken? Right?
Well, does number 1 address that only the Board of County Commissioners may authorize the initiation of criminal prosecution for violations of this code?
It does not, because a civil infraction is not a criminal violation. So in essentially B 1 through 4 are effectively 4 different, you're gonna appreciate this from the meeting we had yesterday on a total different topic. But essentially B 1, 2, 3, and 4 are 4 different avenues to enforcement, but not to everything, but to the portions of the code that they apply to. So it can get a little complicated. So a criminal prosecution, here, I'll give you an example. Subdividing it and filing a plat, without going through any process, just dividing a piece of property and creating it and going and filing it and selling that piece of property, right? That's a criminal violation. Okay?
Wasn't aware of that. Go ahead.
Okay, so yes, the civil infraction process, the way this is written, is that B, again, we're focusing on B 1 through 4, because those are, that all of the options 1, 2, and 3 require the Board of County Commissioners to refer or authorize those. And those are, you know, getting a little bit more serious, okay? Civil infraction, and I've said this before, I think it is akin to a traffic ticket, okay? So, and maybe I'll ask you to think about it that way, because procedurally, that's fundamentally what it's gonna look like, okay? And so when you're going 10 miles per hour over the speed limit, and someone pulls you over, State Patrol pulls you over and gives you a ticket, summons a complaint for 10 mile per hour over the posted speed limit, and it's a $170 fine or whatever it is now. That is a traffic infraction. This is a civil infraction. An infraction is a civil matter. It is not a criminal matter. So, that is the absolute lowest enforcement tool that this allows. So, when
So
this
I
was,
guess the
when this was
question-
written, it was, well, the code enforcement officer might have that authority to do that.
To actually issue the summons complaint, but when you look at number 3, the summons complaint goes to court.
That's a different thing.
The difference.
This is,
Okay,
and
that's why I just
this
wanna-
gets really confusing, and I'll be honest with you, attorneys get confused about this as well. There is a difference between a county court civil action and a civil infraction that gets written in the county court. They're different things. The civil infraction is like a traffic ticket. A civil action is like a little mini lawsuit.
Okay, so I guess the question before the board here is,
It's,
where, if at all, do the BoCC get informed or become engaged in a civil infraction?
I think that's a question that has been kicked around for at least a couple of months, if not longer,
Yeah.
yes.
So, and the second point to your topic here, how this could be easily confused, those 1 through 4.
Mhm.
Would it be worthwhile putting into here, an example is for each one?
No, because,
Trying
sorry,
to
I'm
get
answering
you-
very quickly because these are not exclusive.
I understand, but
And so this particular factual violation, the county, I'm saying the great county, the Board of County Commissioners and everyone down from there, may choose to enforce in this manner instead of this manner. So it's not something that you could factually break something out.
But I'm saying under criminal prosecution,
Mhm.
an example of would be something very easily understood, and an example of an injunction or a civil infraction as a speeding ticket. I'm just trying to make it easier for people to use and understand.
So we run a danger here, okay? Anytime we get into something like this, the vast majority of everything that is written here in chapter 13 is simply a representation of what the statute says, okay? Most of this, frankly, doesn't even have to be in here. Most of this does not, because all you're doing is reiterating what the statute already authorizes. So there's a danger when we start poking in there and making an example or changing this and changing that, that all of a sudden we become contrary to the statute. And then we have a law, a county law, that says something maybe very close, but just a little bit different than the statute. And then we're kind of in this no man's land. So I would be hesitant to start putting some examples in there. I understand somebody, a layperson looking at this and saying remedies, all this, but frankly, these are the types of remedies that could be available depending upon circumstances. In land uses, you're touching everything, you know.
I understand.
You're touching, well, I shouldn't say that, because probably later on in 20 minutes here, I'm gonna say, no, it doesn't touch that, but it touches a lot. It touches a whole lot. And you're talking about subdivision regulations, which have statutory provisions, zoning, which has its own statutory provisions and enforcement and that sort of thing, so. And then the civil remedies, obviously, in county court, and different things.
So commissioners, let's get back to number 4 here. Where, if at all, would you want to see the BoCC involvement?
The challenge we have here is the BoCC also basically works as the repeal board for everything. You know, if there's a decision, you know, that's made by staff, by the county attorney's office, ultimately it falls back on the county to make a final decision on. So I think we gotta be careful at what point we're involved. Correct me if I'm wrong, John.
And just kind of maybe as a quick reminder, and just for, so everybody, the way the process is working is we get a complaint, we go out, if there is if we find something, we will issue an advisory notice. That's not a notice of violation yet. It's not, you know, until we've gotten through that advisory notice and aren't making any headway, at that point, then we would go to the advisory committee and make a determination whether or not a notice of violation should be issued. That is the kind of called the formal start of a violation. Everything before that is informal, trying to work through it, and come to a conclusion. A summons and complaint would not come until after there was a notice of violation.
And also, and we talked about this before, also after a review within the Code Compliance Advisory Committee, did I get it right?
Yeah.
Okay. As well, you know, that there's an internal, and Chairman, we spoke about this again.
Yeah.
We've been down this road, and that was, you know, kind of where, what we discussed in that.
When we flagged this, because we wanted to. Personally, if you've issued a summons and a complaint, I would expect a phone call. And from constituents saying, I received this, and I'd like to at least be notified. So I get a heads up before we get that call.
Is there a problem with just inserting the language, BoCC will be notified prior to the summons and complaint?
Or along with.
So kind of something like the code compliance officer may issue the summons and complaint after notification to the board or after presentation to the board, something like that? I'm kind of looking at John too.
Well, frankly, my preference would be to leave that stuff out of this document and put it in policies and procedures. To where, you know, you've got a board, you've got a county administrator, you've got a director of planning, you've got a code enforcement officer. There could be policies and procedures that are developed that says, before that summons and complaint is put in the mail or served or whatever, however it's gonna be, that the board is notified. I think that fits better than putting it in here.
That's fine. Does that work for you guys?
Yeah. That would be something we have to keep in the back of our mind when the public reads that. And, thinking that our code compliance officers has the authority to write that at his will.
And those policies can also, the internal policies, again, from the county administrator through the director of planning through the code enforcement officer, can speak about the role of the code compliance advisory committee as well, that those need to be at least reviewed or staffed through that committee. But I think that could be built into the procedures.
I've already got it established, so it's easy for you.
So from the policy and procedure, not land use code, what is the board's preference for prior to issuing a citation, a summons a complaint, do you want it formally in front of the board, or notification, or?
I just would like to get a copy of the summons and complaint.
So notification.
Yeah. Stick it in my mailbox.
Okay.
Okay, anything else on the first page?
You guys ready for C, non-liability? John, you said, in my notes here, it says, we could delete that whole first sentence is highlighted in yellow.
I thought it already was.
Yeah, I thought we decided.
I thought that,
Decided to take that out already.
Okay.
so I think what we.
It was new language, and trying to show it as new language to be taken out, that's why I just highlighted it.
Okay, that's fine.
Two negative, one positive, two negatives. So I think that would just, that paragraph would just start with enacting this code, sorry.
That works. Administrative remedies. Looked like there was some cleanup in the language.
Yeah, I think the cleanup on that's fine, I don't think there's any problem there.
Mike?
No, it's fine.
E, subdivision violations and remedies. Any other changes there? Again, we got a highlighted yellow.
Yeah, we were just gonna pull that out because it was.
Well,
So this was
the
your
yellow is
adding-
added.
Yeah,
The yellow.
in this case, this was intended to add from the last time.
Oh,
that
look,
you've seen
somebody
this.
added an example.
I think Chairman Coots might have wanted that.
That was a specific request, to have an example, yes.
So I was under the assumption that the yellow meant it was gonna go away, so.
On the first one, yes, not on this one. Yeah, sorry.
And I don't see what we gain by this one here. As an example, pursuant to CRS blah, 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 any division of land which creates parcels of land of which compromise 35 acres or more, 35 plus acres of land, and none of which is intended for use by multiple owners are a definition not considered a subdivision.
So, Mr. Supas, I think the discussion when, at a previous work session was, when that didn't exist, was that, that sentence before that references 3028-101 sub 10, which is a definition of subdivision. It's not terribly easy to read, but it's, you know, it's not horrible, but it's not in there. And so I think the discussion at that time was, let's give the example, the one that many people are looking at, of a non-subdivision division of land with everything over 35 acres and none of which are intended for use by multiple. So, to give that example, that was the discussion that was happening, that's why that was entered in.
To add some clarity on that 35 acres.
And
It's just,
so,
I'll look at it.
so what part of the statute doesn't allow a 35 acre split to be sold?
it doesn't, there's no rec,
But,
it's not, we're talking about, if you had 100 acres, you could go ahead and split it and not have it be created
you know,
a subdivision.
why do we need to add the multiple owners language in there?
It's directly out of the statute.
That does come out of the statute.
I took that language directly out of the statute, because again, I'm very sensitive to someone writing something that's similar to the statute, but the minute we start playing with words or writing what we think it says, is when we're gonna get in trouble.
John and I have had a lot of conversation around this.
My preference, if you're gonna do that, then leave it out completely. But this language is right out of the statute. And in fact, and Carl's showing me on, in the definition section, subdivision land is already defined, and it would be, with just glancing at it, it's gonna read the same way.
Right.
Which is out of title, And that's not the entirety of the definition, but that's the one that is most, seems like we discuss the most at meetings like this.
Mike, Don, where you at?
I still feel like it mucks it up a little bit, but the state statutes muck up most everything, so.
I just want to give people surety in here that they can do that.
Okay.
So the multiple owners language is also in the definition of subdivision, as John just mentioned. Subsection A, any division of land which creates parcels of land, each of which comprises 35 or more acres of land, and none of which is intended for use by multiple owners, which came out of statute.
Good with me?
So I don't know if it takes away anything to take this example out of the definition, or.
It's just putting it out there for people to see if that's what we want.
Any other discussion on section E?
I guess the C seems a bit redundant in there.
So A and B is good as it stands then?
With the example?
Yeah.
I don't remember where that's at, Commissioner Shipus, but there's language about, the recordation as well. I'd have to dig for that,
Okay.
exactly where that's at, but,
It does come out of the statute.
Yeah.
Okay.
Other than there's a typo, so such land has been subdivided, that last sentence. Rather than such land been, it should be has been.
probably.
Okay, what about conveyance there then?
So, sub A is directly out of the statute, which again, it just says what it says. And this one, I'll draw your attention to fourth or fifth line down, depends on how you're counting. On the left side, it is, it makes it clear that the person who does this, is guilty of a misdemeanor. A misdemeanor is a criminal offense. Okay, so this is the statute that I was talking about. So, the state statute says if you do this, that is a criminal offense. But that just reads exactly like 3028-110 sub 4 sub A. There's some significant limitations on that too, if you read through it, but.
Yeah, there is.
Specifically, the statute of limitations is only 18 months on that, which, you know, is interesting. I don't know that I've ever seen this prosecuted, but it's there.
A and B to me can stand as amended there.
So, sub B at number 2, and sub C at number 1, are exactly the same, do they need to equal?
Well, let me look at that statute, Carl, because it's, the above is talking about dividing land.
Right, and then this is talking
And
about.
this is talking about
contract deeds
conveyance
and-
of
right.
land. And even the terms of the, or the documents that they're referring to, you know, when you're talking about a plat, map, or other instrument creating a division of land, that's what we're talking about up top. And then here we're talking about, conveyance of land, which is a
Includes
deed,
deeds and other
yeah,
documents.
yeah, yeah.
Mike, Don, anything else on 2A, 2B?
Seems like we get a little wordy, but we were trying to avoid that, but just reiterating statute, so.
I mean, sometimes there's a value to reference statute in the land use code, and other times, you know, obviously we don't need to because there is statute, but it's, what do you wanna have here for people to be able to see rather than having to dig through and find it in statute somewhere?
I guess my challenge here is the only thing we're referencing statute in is how we can show our teeth. You know, it's less about being constructive, more about, hey, you better not. And it's the tone of the document that has me concerned here.
You know, you could say reference at CRS. And
I've been reading through some other codes and, you know, there's similar language in the Montrose Code and the Mesa County Code. And we just, like I said, it just seems like an effort to show our teeth here and show how powerful we are rather than, you know, hey, this is what you can do with your property type discussions. So, like I said, it's just the tone of the document that I'm concerned about here.
But this is the chapter on code enforcement and remedies.
No, I understand that, but, you know, it's.
Because the other line of thought would give people easy access to understand what the state statute is. Because we have to abide by two.
Like I said, I understand that, but.
And restricting a lot too. Look at the paragraphs below that.
Yeah, we took out page and a half.
And from C on, is crossed out and document on it.
John, I did have a question.
Okay.
What is a mandamus?
It's geez, you gotta think about that, you don't even use the term hardly. I'm gonna look it up, because we don't hardly use that anymore.
Do you need to see it in context? It's under the stricken part of land use planning violations and remedies, paragraph 3.
It's a mandate, okay. It's essentially it's an order coming back from an appellate court to an inferior court, to, for instance, a trial court or something like that, to carry out whatever they're saying it to do. But again, that language is right out of the statute. You know.
So are we ready for section F?
Zoning violations and remedies.
Yeah. I don't think we had any real changes until we hit pre-existing
So there's a couple of things, on B, that's just a typographical error, that would be 3028-124 rather than 104.
124?
124, so 1B.
So that's F, 1B.
That's F1B, it's just typographical error. So this is the section, Chairman, that, that really kind of lays out, and, sorry, I'm talking about 3028-124, really, and 3028-124.5, which is the very next one, that kind of lays out some of these remedies. Specifically now, the civil infraction in subsection 1B, Roman numeral 1, but also, and that's the civil infraction side, and then on the, but also the civil remedies that we're talking about, the civil county court remedies as well. So this is really the heart of when you're talking about enforcement, although it's not terribly clear, but when you're talking about enforcement of zoning regulations, it's really in these two sections, 124 and 124.5.
So I'm still a little bit above that one yet on, section 2, condition compliance.
Sorry, I was all the way back up still on F and G, F, but that's okay.
Oh, okay.
I'm just giving the overview.
Oh, that's a 124, I see what you're saying.
Yeah, that's okay.
Missed that.
That's it, yeah.
Okay, we've covered this one before. We had flagged section 2, condition compliance.
And this is one of those that I assumed that we were gonna add, not take out on the highlighter.
Yes.
Okay. I'm fine with that.
Okay. One in a row.
Gotta start somewhere.
We're gonna start somewhere.
I aim to please.
You're all right with that one, Mike?
Yes.
Okay.
So Chair, before you move on, I would like to discuss subsection G, which is the bottom of the page immediately previous to that, and it's regarding the manufactured housing violations and remedies. I think there's been various conversations about this topic at various meetings over the last, I don't know, 10 years? No, more than that. But specifically over the last, period of time, months and that sort of thing. Yeah, I've never really been in favor of this being in here. I realized that the board basically wanted something in there. I'll be honest with you, I'm not really sure where the authority to regulate that activity lies.
How so,
And-
John?
What's that?
How so?
Well, what we're trying to regulate in that sentence is to force someone to get a moving permit. And,
As per required by state of Colorado through DOLA.
okay, all right. And so the first thing would be, does that fit into, is that the type of topic that is appropriate to regulate within a zoning regulation, a zoning resolution like this? It might be, it might not be. The second thing I would say, and I've said this before, but I pulled out the citations, is this activity is already prohibited by state law. And specifically, you have the tax collection part of it, 395205. So anytime a mobile home is to be moved, the taxes, you guys understand that portion of it. But then 424510 sub 2 sub A is the requirement to get a permit. And it seems like we're trying to regulate the exact same thing that Title 42 is trying to regulate. And I don't know, but there could be an argument that the state has preempted this, and the state has said, we are going to regulate, we are going to make our law about this thing. So county, you really can't come underneath of us and make the same law. That's called preemption sometimes, okay? And let's talk about what that is. So if somebody is doing that, moving mobiles without that permit, it's a class 2 misdemeanor. Again, a criminal offense. Possible penalties up to again, criminal offense that is not part of our land use code. Up to $750 fine and up to 120 days in jail. Of course, most people are not spending 120 days in jail for doing things like this, but those are possible penalties. So I think there is a concern that the state has already regulated and preempted this field. So I guess I'll just throw that out there. Why are we trying to regulate something the state already regulates?
This was pre-existing in the 2021. Do you remember what the thoughts were there?
I don't think it is.
Wasn't?
No,
I don't think it is.
wasn't. This was part of kind of trying to align the pre-HUD mobile home ordinance, had the mobile home park ordinance, and those types of things, as we were trying to get more into the land use code and less in appendices.
Okay, well, if it's not in there, John, I would be in favor of referencing state statute and the process. We don't need to do that.
But then, I mean, do we even need to reference it if it's not?
Again, I think we should note that it does require DOLA be engaged.
But this is enforcements and remedies of Delta County's code.
Yeah. So I can see striking it from here.
No, that's your.
My recommendation would be just to get rid of it. It's already there. We know that. And again, the people that are going to be managing and working through these processes in the future, out of planning, out of the treasurer's office, out of wherever, they know this is here, and what that would take would be obviously some sort of investigation, but a referral to the county sheriff, because it's a criminal charge. So the sheriff would be the one that would be issuing a summons and complaint, but it's a misdemeanor. It's not even a traffic. You're thinking, when I first looked at this, I was thinking it's some sort of a traffic, because you're dealing with a permit to pull over the road, but it's not. It's a misdemeanor charge.
Is there anywhere else in the code that does reference a requirement for the DOLA permit?
I don't believe so. Let me check chapter 2.
Same with plumbing and electrical inspection, I think it should be.
Yeah, I mean, if we're gonna mention it, that's what it should be in chapter 2 under the manufacturing.
Right, that's where I'm looking now.
If we're gonna reference the statute there versus referencing enforcement remedies. Cause it's not ours to enforce.
Well, it's the county's in the grand scheme. It's the sheriff's.
It's the sheriff.
It's the sheriff's. It's not ours land use to enforce.
Exactly, exactly.
I think that's a good catch.
I think it's a lot like when I do a littering issue. I'll do the investigation, I take the pictures, I create a report, and then because it's littering, it's actually criminal. And I just forward that to the sheriff's department, who then goes out with my information and does the case and chooses to issue a summons or not.
So in chapter 2, the manufactured housing units does refer to, it has to be installed pursuant to Colorado 8 CCR 1302-7 per the DOLA installation program. No manufactured housing unit may be moved without completing a development application, and proper steps and paperwork necessary established by the county to sell, move, set, or demolish a mobile or manufactured home.
We could reference those two statutes right there as well. I mean,
Okay.
It just gives it a little bit more.
In chapter 2 rather than here.
Right into that paragraph.
Okay.
Yeah, we can just reference those and then.
Yeah, that's good.
Much better. Good catch.
Okay, sorry, I pulled you back up there.
That's all right.
Under additional remedies on the next page, one, I think it should read code rather than ordinance in that first page. And there was one other that used the word ordinance, I don't know, oh yeah, on the next page. Cause this is a code, or this is a resolution, this is not an ordinance proper. But those are just typo things.
You also need this statute.
Yep, absolutely.
Then it goes into additional remedies, and then condition compliance.
Any other questions then, or comment, guys, on section 2 and section 3?
And under B, and Carl, you can correct me if you remember differently, but those timeframes are actually more permissive than the statute requires. I think the statute only requires like 10 days or something like that, so,
Right,
so in a situation like this, it would be fine for the board to be saying, hey, we're gonna give people 30 days.
We need more time.
Because it's more, where the statute says 10 days, I think you can give more, and I think we've discussed that before.
There's 2B, built in our discussion the other day. The second paragraph,
Are you talking about the issue we had in that other meeting?
yeah.
Well, that's not in the land use code, so those are different statutory enforcement processes, so. So the next section is particular about the civil infraction, process. And again, so it's only just one of those 4 different, avenues towards enforcing certain aspects of this code. And A just says generally this is a fraction, that's just kind of reiterating what the statute says. And B is what I referenced earlier, is just because it's a civil infraction now, doesn't mean that the penalty assessment process is authorized. And so let me give you an example again, when you go back to that traffic ticket that you get. So usually if you're going 10 over, the officer writes you and says, pay your $173.50 or whatever it is. Or how much is it now for?
Depends on if it's state or muni.
State, it's close
Well,
to that.
state at 10 to 19 over, it's $279.
Oh my goodness, okay, it's more than that, okay, all right. So, but that's a penalty, so if you pay that, you don't have to go to court. Okay, because it's a civil matter, it's effectively a civil matter, that's what a penalty assessment is. There is a set fine, essentially, you pay it, you don't have to go to court. So, but you can also have a summons, where you are, or even though it's a civil case, you are ordered to court. And that's get too complicated, too in-depth there. But essentially, one thing that this board does have before it is, are you going to authorize the penalty assessment process? So that we, again, the Royal League, the whole process, has the ability to issue a penalty assessment. Make sense? You follow that? Otherwise, you don't have that option. Otherwise, you don't have that option. It also doesn't mean you're ever gonna do it. Or you're gonna do it in rare circumstances. We've already discussed, it's gonna be code enforcement with the direction of the director, possibly the county administrator, and then running it through the, advisory committee, and then also the Board of County Commissioners being notified. Goodness, all right. C, we talked about it, we've talked about this before, is the graduated fine schedule, that can be adopted. And then D, I'd also use the word code rather than ordinance.
So at this point, we have adopted the graduated fine schedule for junk and rubbish.
Just for junk and rubbish.
Not for land use.
Correct.
Robbie, we're just about ready to get into chapter 13, section 4.
We have good news on the bridge, so.
Good here.
Let's spread it.
You guys ready? Any other questions on B, C, or D?
I'm good.
Section 4, let's start with complaints. We've kicked around both signed and unsigned, advance notification of property inspections.
Yeah, so this is kind of also getting proactive versus solely reactive. Does it have to be signed, or can somebody file a complaint? If somebody were to file a complaint and not sign it, it's still reactive, you know, but proactive could be looked at as, you know, a road and bridge foreman is driving down the road and they see an access that was installed and it's not permitted, it's in an unsafe location. That couldn't be looked at as proactive because, you know, but it could also be reactive in that they're seeing it and then filing a complaint.
Well, and that's, I've had this discussion with many constituents regarding the proactive versus reactive. And, I'm very much on the reactive side, but if we have something that's life safety, welfare, we need to be able to have that ability to do proactive work on it.
Right.
So, I mean, I think there probably needs to be a line in the sand there, and I don't know how you define that. But, you know, there's, you know, we don't want, we've been clear with Everett that we're not gonna go down that road, but we don't want a future compliance officer just to spend all day driving around looking for compliance issues.
Right, and that's not the
But like
intent.
you said, if a road and bridge guy sees something that's dangerous, you know, it's something we need to be able to take care of without waiting for a neighbor to complain on it.
Right.
But when you get to zoning, you can have significant zoning violations that no one files a complaint on, but they are significant violations. Clearly, you guys know what camp I'm in. I think that you need to at least give the option to have our personnel to be able to do their jobs. And you handle those types of things through policies and procedures, not in this. Also read you something out of the statute. The statute seems to clearly give the authority to the zoning official. Whenever a county zoning official authorized pursuant to, and it talks about, and this is, you say, how do you distinguish? I'll tell you how the statute distinguishes. Has personal knowledge of any violation of this paragraph, which is all the zoning stuff. He or she shall give written, it's actually shall give written notice to the violator to correct the violation within, and this is where it gets into 10 days. We're saying, hey, you gotta do, a little bit more. So, that's clearly, I'm in that camp, because I don't see creating a law, that's what we're doing, that takes the tools away that might be needed in the future, because we can't anticipate, we can't prognosticate exactly every situation. But we can control those things through the administrator, the director, the code enforcement, the directive of the board through policies and procedures, through the, code compliance advisory committee, and those sorts of things. So, but that's my position. You can, of course. Yeah, so.
And when we redid the junk rubbish ordinance, it did not require a written complaint anymore when we recently
Correct.
updated that. Because there were people that were saying, well, if I have to sign it, I'm concerned about retaliation or whatever that might be. And so then they would not file a complaint. So that ordinance actually currently has been written, that it does not require a written complaint.
And to be clear, and I don't know, there's been a lot of discussion about this, and rightfully so, this is a sensitive area. To be clear, the existing 2021 land use code does not require a signed complaint. And I think that there's been some talk that maybe it did, or maybe there's some confusion there, whatever. It does not. In fact, it's silent on this.
The
Silent
junk
on-
rubbish ordinance
The
did.
junk rubbish ordinance
Right.
does. Well, it did, and now it
Did.
changed, you know, because that's been updated. But the 2021 land use code does not require a written complaint.
Correct.
It's silent on that issue.
Yes.
Which, well,
I understand what you're saying. I'm still, coming from the private sector, seeing what a rogue inspector can do, it's just one of those things that makes me nervous. You know, we've had these discussions with Everett. I'm not worried about it. It's the future. That who knows what's in the future, and that's what makes me nervous. And
and with all due respect, Commissioner, we also need to be concerned with a future board. Because if you put language in here that restricts a future board, then it's in there. And clearly, we see how easy it is to amend the land use code. I mean, it's difficult. It's really difficult to go through these processes. And so, you know, you're making law here that is going to be the law of the county, until it's changed, which is difficult to change, very difficult. That's why policies and procedures that are handled within administration by directive of the Board of County Commissioners, those can be changed at any time.
And in those right now, that's why we've added the advisory committee to have a layer of oversight, and then, you know, and then ultimately, the board has that appeal authority, if you don't feel it's a violation.
Everett, question for you. How many complaints have you gotten that did you find to be without merit?
Percentage wise.
5%. Sometimes they end up with just angry neighbors going tit for tat. I would say probably,
So, let's take junk rubbish out, let's talk land use.
again, land use most of the time. When I get a complaint, a lot of times it's for people building without applications, or maybe the prior documentation that we had for the development ordinance application. A lot of times that's where they call and say, my neighbor's building something, what's he doing? I don't know that I get a lot of, I find more no merit in the junk and rubbish because of how they misconstrue what one person's junk is over someone else's
Or it's exempt by
possession.
ag.
Or it's an ag exemption, I get that frequently. I don't get a lot in land use. A lot of times it's as simple as, hey, they're building something, is there a permit, and are they doing it right? Hey, my neighbor just put it in access, who gave him the authority to do that, it's too close to mine. I think one of the other ones is obviously land use is the RV used as a dwelling is a big one. They're got an RV on their property, been there for 9 months, people are living in it, I don't know where their sewer's going.
But if you go and it's hooked up to water and sewer, it's no merit.
If it's got infrastructure, it's got no merit, and I can say, I haven't had one of those yet. Like I said, I find more no merit with junk and rubbish than I do land use.
Thank you. So, Don, how would you change this if you would? Or would you not change it? Section A complaints.
And maybe what you want in the land use code versus how you want policy procedure
Yeah,
written.
I'm comfortable with section A. I think that's good language. I really think where we are now in section 13, we've taken out a lot of the other stuff. We've reduced a lot of the bad language. I think we've, for the most part, I think section 13 is, you know, it's pretty close to where we want it.
What about you, Mike? Section A1.
Well, it says such complaint may be in writing, it doesn't say have to. And then the county uses that discretion. John?
The statute says shall.
It doesn't say shall
Well, it says
that.
shall investigate if they know, it doesn't say.
It says
If we become aware, then we shall investigate.
Okay.
Yes.
personal knowledge, is the term he uses.
Yeah.
It's pretty low standard, frankly.
So we ready to move on to B, investigation? Okay. So the statute and investigation, did that say 10 days? I can't remember.
It does, it talks about 10 days, and the way this reads is 30, which is more permissive. That's an approach to that, so I think you could either put it in at 10, the way the statute reads it, or this is, I guess I'd probably, because the statute is talking about the NOV within, within 10 days, and this 30 days is actually referring to
The initial
the
site
initial, the investigation. I think maybe in para two, B2, it might be good to have some language in there that within so many days, that if an NOV is appropriate, that's issued. Because the statute is concerned about notifying the property owner. And again, I think you can be more permissive rather than more stringent.
So I guess in
So should
subsection.
that be in the non-compliance part? When we talk about notice of violation, is that what you're saying? And notice of violation given after 30 days, or?
Yeah, I think we could, yeah.
Yeah, B is kind of the, called the
Okay.
voluntary, you know, we're still in trying to work with them. Hence the advisory letter, which is not a notice of violation at that point, it's just, we found something, we wanna work with you. In subsection 1, you know, I get 30 days could seem like a lot of time to the person who filed a complaint saying, you know, when are you gonna get out there? You know, we have 30 days to get out there. In practice, we do get out there pretty quick.
Yeah, we got out there fairly quick, and then when we talk about our internal policies, we have added a step where it's gonna take a little bit longer just because we've added more decision by committee kind of thing. So I would like to see it at 30 just in case, because we don't know.
Cause that's not
how much
just
it
the site
blows
visit,
up.
that's also
Yeah.
doing any background research, meeting with the committee. I'm just thinking out loud here.
Yeah. And most of the time I do get quicker. Most of the time I can get out there pretty quick. But we only meet with the committee twice a month. So that does create just a little more lag, but not a lot.
So we probably have a time frame for investigation, and then a separate time frame for issuance of NOV.
And
Yeah, the NOV, I think,
that's,
is-
yeah,
That's
so
what,
that's,
yeah. And so I just made myself a note to say, build in some language regarding NOV from the statute. So I can pull some language out of here, and in my mind, I'm thinking an additional 14 days or something. Unless you guys want an additional 21 or additional 30, whatever.
I mean, we've been doing 30 kind of across the whole thing, so.
Okay.
And I think
But that means you could be out as far as 60.
Yeah, the standard notice violation is once the notice of violation is issued, that gives 30 days to correct.
Well, by statute, I think it goes 10. I think
10.
We've been
doing 30.
But I halted all NOV, so we haven't really run that until we had a very clear path. So,
But I mean, if we give 30 days after an advisory letter, and there's still no action being taken to resolve the issue, then we've at least given 30 days before we send out the NOV.
well, that'd be a minimum. There's,
Well, if there's no action.
I mean,
No,
I
no
still
response.
work with people repeatedly. There's at least
Well,
2 advisory
But
letters.
once again, that's.
It could be more, it just can't be less.
Yeah.
That's the difference between no action taken, you know, if you show up with an advisory letter, they give you the bird and tell you to go pound sand,
A little
then,
shorter time.
then you got 30 days to come back with an NOV.
Yeah, that makes sense.
Did you reference the statute and the word and the?
That's in the wild, that's Title 33.
That's wildlife.
Wildlife.
Yeah.
Wildlife, yeah.
This is Department of Wilderness. Wildlife.
So from the time complaints filed to the time, when an NOV could be sent out is 60 days.
Not really,
It
it just
doesn't-
says,
it doesn't
it just says
have
it
to
has
be.
30
That's
days
kind of
to
the-
investigate.
Yeah, but it could be,
Could be.
Right.
yeah, that's the maximum
From,
length.
from the time.
I'm trying to think, is that an adequate amount of time before you issue somebody an NOV?
60 days is a lot. I mean, if I literally get the hard stop, which most of the time I don't, most of I can work with people.
Well, again, we have not issued a notice of
Right.
violation in 2 years, so, and we've been working everything up through the advisory letter, because generally people are trying to work with us, and at that point, they're, you know, we don't, we might have a timeline to see progress or whatever, but, we've not issued an NOV today.
Okay, I'm good with this timeframe.
Okay, so Carl, we can pull some language out of
Okay.
that statute and
Okay.
with the concept of up to 30 days for investigation and then 30 days to essentially.
Once the advisory
comply.
letter,
Right.
there isn't anything, we need to move to the next step, then,
Okay,
yeah.
we can work on that.
So under investigation, there's been some conversation around drone use. We have not put anything in the land use code relative to drone use at this point. We did have a conversation about drone use when we had the work session talking about the standard operating procedures for code compliance. And generally it would be used if we needed an inspection warrant and we could not get onto the property, that a drone could be used in that regard, but it would be part of the inspection warrant.
Yes, if we had to force the use, again, the concern for me is, in my background of kicking indoors in law enforcement, there's a high risk there that is really mitigated. If we get an administrative search and seizure warrant, which is them saying we can force our way onto a property through a judge, the mitigation and safety factors of being able to just deploy a drone, get what you need from the air, get your pictures, no physical confrontation, no forcing your way on the property. It is by far the safest way to manage that for the citizens and as for the county staff.
So I personally see this more as a policy issue rather than a code
And that's where we
issue.
were to take.
And I think this is something that should be, you know, just like a summons. Once it has, I mean, once you have that approval, then you do it, but I don't think it's something.
It's gonna be even more than that, because the scenario that Everett just spoke about, the administrative entry and seizure warrant, the board is gonna be intimately involved in that decision long before we get to that point. So that's one of the four, remember we were only talking about the one, that's one of the four that only the board can authorize. So long before you're using a drone, the board's already heard this probably ad nauseum from me or someone from my office, plus, you know, the whole development. So there's gonna be a lot of, it's not something on, I mean, at least that's the scenario you're talking about right now.
Yeah,
Very-
no, Everett's not driving out there and launching his drone.
That is an extreme, also the drone is extremely helpful when you have a mitigation program with a cooperative landowner. And we are trying to do a phased mitigation, real-time aerial photographs with consent for each zone. Usually we do zones with X number of days to go through each phase to work with them within their abilities. It helps to be able to zone that out with current photographs of exactly what our goals are. And even then, with consent, it's a totally different situation.
That's not an enforcement, that's a
Yeah.
documentation.
Correct.
Well, it is well, yeah, I mean, it's enforcement in the grand scheme if somebody's even, voluntarily complying. Yeah, you have a policy that says nobody uses a drone until it's approved by blank. It's approved by the county administrator, it's approved by the board, it's approved by, the committee, it's approved by the director, whatever the will of the board is.
Yeah, so, because there'll be another technology come along, we'll have to.
But how long are we from using, I mean, you already have GIS that has pretty good resolution.
Yeah, the aerial photos are a pretty good resolution.
I mean, we already have
Before we
that.
even
You know, everybody
go
has
out
that.
there.
You know, everybody has that. You already have that, or, you know, that's the
But
technology.
it is a point in time,
Yeah.
you know, things change.
Agreed, yes.
Okay.
Yeah, unless you needed real-time information.
Right. I think D was, I don't remember, Carl, is stricken. All that is already addressed somewhere else.
Yeah, it's more of the
The-
and the SOPs.
Yeah, D and E.
So what we've got right here, it's about 4 1/3 pages in chapter 4, which is, I think, manageable. We got a bunch of the language out that was questionable. I think we've softened outside statute on plenty of it. So,
Well, realistically, the things that you have inserted is more permissive than the statute.
right.
And that's in the true enforcement process. It's more allowing or permissive for the most part.
So, John, you're gonna make some minor edits there, get us a clean copy of.
Yeah, I'll work
Chapter 13.
with Carl, because he was taking notes and I was taking notes, and we'll make sure, I mean, most of it was in chapter 13, you have the one in chapter 2.
Right.
So yeah, and then I can kick well, I tell you what I'll do, is we'll kick this back with the changes, but then I'll accept all the changes. So we don't have all these strike-throughs to confuse us.
Right.
And then you can see, you know, yeah, clean version.
Okay.
All
We
right.
actually got through that quicker than we thought we would.
I mean, that is what we set today for, was to get through this chapter, so, you know. Wanna go, are you,
It's Friday afternoon, gentlemen, did you wanna jump into any other part of the code today? Or you wanna schedule next?
I think, you know, our next chapter 7, 8, 12 are gonna take a little more time, a little more in depth. I don't think we wanna try to start piecemealing in right now. Personally, I think we probably call it a day with this one, in my opinion.
Mike, you good with that?
Yep.
scheduled to go over the final, but it's the time set aside it from 9 to 11 Monday morning. Not to go over the final,
Obviously, not.
obviously.
Aspirational, but we'll still get there.
Right.
So Monday at 9, can we, and I don't know if you're available, John, but let's,
At least, yeah, at least in the first part, but yeah. for sure.
let's pick up on the language in 13. Make sure we got everything. Does that give you enough time? There's always
Got the
evenings and
weekend.
weekends.
There's not that many changes realistically, so yeah, sure, no problem.
And then Carl, you're gonna work a little bit on chapter 2 on the DOLA permits for,
Right, and manufactured units, right.
and then we'll cover chapter 7 and
Okay.
8, 9 to 11.
And on manufactured units, I just wanted to say that the DOLA is working on some administrative regulations. The tiny homes follow similar guidelines to manufactured units, so, I just wanna make sure that's out there also, as we're thinking about manufactured units.
Very good.
Sharon, are you gonna try to schedule, are you gonna wait till Monday and maybe schedule some from?
Yeah.
Additional.
Okay, additional after that?
Yes.
But wait till Monday.
Well, thank you, everybody. Everett, appreciate your input. Everybody have a good weekend.
Thank you all for coming.
Please remember Partners Palooza, putting in a plug for Lindsay here.